All right, so we are going to now trace one of the longest, most consequential doctrinal threads in American constitutional law. How the Constitution has defined, redefined, and constrained the use of race by the government, from a Supreme Court decision that denied an entire race the possibility of citizenship, all the way through a 2023 decision that ended affirmative action in higher education, as we have known it for nearly 50 years. Now, along the way, we're going to kind of step outside of the Constitution entirely, and we're going to talk about a federal statute, which is Title VII of the Civil Rights Act of 1964, because employment discrimination law runs on a completely different set of rules than than the constitutional equal protection law does. And understanding why those rules differ is probably the most important lesson this lecture has to offer. Now, I want to be upfront with something before we begin. Several of the cases that we are going to study today involve language, reasoning, and historical episodes that are genuinely difficult to sit with. Language, describing Black Americans as, in the words of one Chief Justice, as quote unquote being of an inferior order. We're going to read that language not because it is comfortable, but because you cannot understand American constitutional law without understanding exactly what the Supreme Court once said in the court's own words and exactly how far the law has had to travel since then. So it's about historical honesty, and that's part of what makes you a competent legal professional. So we're going to treat this material, seriously, and I trust that you're going to do the same. So let's dig in. All right, so this lecture is going to kind of unfold in four different parts, and I want to give you the shape of the whole journey before we kind of take the first step, because it'll help you to see how each part is going to build on the one before it. So part one is the constitutional backdrop. So we're going to begin with our, our toolkit, right? The levels of scrutiny that the courts use whenever the government sorts people by race. And then we're going to walk through three of the most important race cases in American history. That's Dred Scott versus Sanford in 1857, which held that Black Americans could never be citizens under the Constitution. Then we have Plessy versus Ferguson in 1896, which, blessed the government mandated racial segregation under the doctrine of separate but equal. And then Brown versus Board of Education, which was decided in 1954 and 1955, which finally unanimously tore down that particular doctrine, the separate but equal. Now, the final part is going to take us not too long, but the first part rather, it's not going to take too long. And it kind of sets up everything that follows, because the strict scrutiny standard that we're going to develop here in part one is the exact same standard that the court will apply decades later to affirmative action. Now, part two is going to turn from exclusion to inclusion. So, 2 decades after Brown versus Board, we have a genuinely new question that reached the court, and that is, can the government use race not to harm a group, but to help one? And specifically, can a university consider race in admissions in order to build a diverse student body? We're also going to look at two companion cases that were decided by the University of Michigan on the very same day in 2003. We have Gratz versus Bollinger, and then we have Grutter versus Bollinger, which reached opposite results using the same exact legal test. And then we have part three, which carries the story forward into the 21st century through Fisher versus the University of Texas. And it was decided twice, once in 2013 and then once in 2016. And finally, to the student for fair admissions versus Harvard, which was decided in 2023, which is the current controlling law and which functionally ended the affirmative action framework that we will have spent some time, kind of building up. I hope I hope this ending is going to feel different than you might kind of expect, walking into this. Part four is a very genuine kind of shift in gears, because we're going to move away from the Constitution entirely into Title VII of the Civil Rights Act of 1964, which is going to govern the discrimination in private and public employment. So this is where you're going to learn the rules for suing your employer over race discrimination and what those are. Um, and in some ways, it's easier to satisfy than the rules for challenging a government law under the Equal Protection Clause. And exactly, why that is true is one of the central goals kind of today's lecture. Um, so we're going to kind of close with, talking about that, hopefully to bring together this framework. Now, before we can meaningfully analyze Dred Scott or Plessy or Brown, we do need a shared vocabulary. That's the doctrinal toolkit that courts go for anytime that they are trying to sort the people out, when it comes to race. Without that, those cases will look like a disconnected parade of historical episodes, right? Without it, you will see that every single one of them, separated by more than a century and a half, is answering variations of the same legal question. Now, let's start with the text itself, because everything else that we discussed today, in one way or another, is an argument about what these words mean. The Equal Protection Clause of the 14th Amendment says that no state shall deny to any person within its jurisdiction the equal protection of the laws. Notice how short that sentence is. It is literally 14 words, and those 14 words are carrying more than a century and a half of litigation on their back. Okay? The 14th Amendment was ratified in 1868, and that was 3 years after the Civil War ended. And it was one of 3 amendments that was passed during the Reconstruction era. And it was specifically to remake the constitutional status of formerly enslaved people. Okay? The 13th Amendment, ratified in 1865, I believe, that abolished slavery outright. The 14th, which we're focused on today, it established citizenship and equal protection. And then the 15th, which was ratified in 1870, protected the right to vote from being denied on account of race. Now, read together, those 3 amendments were Congress's attempt to constitutionally undo that legal, architecture of American slavery. All right, which we're going to talk about in kind of painful detail in a few minutes when we get to Dred Scott. But I wanted you to notice 2 structural features of this text that are going to matter throughout this lecture. First, the clause says no state shall. And this is what is called the state action doctrine. Okay, so the Equal Protection Clause, by its own terms, restrains government action. It does not, standing alone, reach purely private conduct. So if your neighbor discriminates against you personally, that is not an equal protection violation, no matter how wrong it is, because your neighbor is not the state. All right, that distinction is going to become important when we shift into part 4, which covers the Title VII, which was specifically designed by Congress to reach private employers in a way that the Constitution alone cannot. And second, I also want you to appreciate that the Equal Protection Clause does not ban all classifications by government. Okay, the government classifies people constantly, like by age when it sets a legal, driving age, by income when it sets tax brackets, by professions when it licensed doctors, requires different rules for lawyers, all those things. None of that is remotely controversial under the Equal Protection Clause. So the real question the 14th Amendment forces courts to answer, and I mean again and again, is not did the government treat people differently? Because it did. Of course it did. The government treats people differently constantly. But rather, which of those classifications should trigger heightened judicial suspicion? That question brings us directly to the 3 tiers of scrutiny. Now, constitutional law has developed a tiered system for answering that question. And I want you to think of these 3 tiers less as like a rigid checklist and more of like different levels of skepticism that a court brings to a law, depending upon, what kind of classification is at issue. At the bottom sits the rational basis review, which is going to apply to essentially everything else. Okay, like the economic regulation, the age classifications, your wealth classifications, the ordinary business of government sorting people into categories basically for administrative purposes. Now, under the rational basis, the government wins almost automatically. The challenger bears the burden of proof, and all the government needs is a legitimate interest and means that are rationally related to it. So, courts applying rational basis review will often accept even a hypothetical justification that the legislature never actually came up with. And that is by design an extremely easy standard for the government to satisfy. Now, in the middle sits the intermediate scrutiny, which is going to apply primarily to classifications based on sex or gender, and to a narrower category involving legitimacy, meaning like whether a child was born to married or unmarried parents. Now, here the government needs an important interest, not just a legitimate one. And the means chosen have to be substantially related to achieving it. Okay, so the burden shifts to the government to justify the classification rather than sitting that with the challenger. Okay, now at the top, and it's the standard that we're gonna kind of spend all of today examining, is strict scrutiny. That is triggered by classifications based on race, national origin, and in some circumstances, alienage. Okay, so here the government has to show a compelling interest, the highest bar that the law recognizes. And whatever means are chosen has to be narrowly tailored to that interest. Okay, so the burden of proof sits entirely with the government. And as we're going to see kind of in detail, that burden is it's exceptionally kind of difficult to carry. Strict scrutiny has earned an informal reputation among law students and practicing lawyers alike as strict in theory but fatal in fact. Okay, meaning that once the court applies it, the government usually loses. All right, so kind of keep that phrase in your back pocket there. The strict in theory, fatal in fact, because you're going to see it proven true again and again through today's cases. Um, Now, let me kind of offer a quick illustration of how differently these three tiers operate in practice, because the abstract labels can blur together if you haven't seen them yet applied. But just imagine that a state passes a law requiring like commercial truck drivers to at least be 21. So, challenged under rational basis review, that law would almost certainly survive because age correlates plausibly enough with driving experience and judgment that a court will accept the state's justification with very little scrutiny. Okay, and so the challenger is going to bear the burden of proving otherwise. Now, imagine that they pass a law treating men and women differently, and in the context of a state run like military academies admission policy. That law would face intermediate scrutiny, and the state would need to show an important interest, not simply a plausible one. And they would also have to show a genuine substantial relationship between the classification and that interest, not a mere loose correlation. Okay. Now imagine that a state passes that they pass a law that it's explicitly reserved a fixed number of public contracts for minority owned businesses. That law is going to face strict scrutiny. So the government bears the burden. And as you're about to see across everything we're going to talk about, that burden is very difficult for the government to satisfy, regardless of how sympathetic the underlying purpose might actually be. Since strict scrutiny is going to carry the weight of this lecture, let's kind of slow it down and take it apart piece by piece. Because the two halves of this test, which are the compelling interest and the narrow tailoring, they do very different work, and courts have developed, very specific rules for each one. Now, starting with the compelling interest requirement, this is not simply asking whether the government's purpose is legitimate or even important. Those words are for rational basis and intermediate scrutiny, respectively. Okay. Compelling is a different order of magnitude, like altogether. Courts have historically accepted only a narrow list of interests as compelling in the racial classification context, specifically like remedying identified specific instances of past discrimination committed by that very same government actor. And in some more narrow settings, you might have like like genuine national security concerns. But what courts have consistently rejected as insufficient is worth memorizing, because you'll see those arguments raised and rejected throughout today's cases. So administrative convenience, not compelling. All right. No matter how much money or time it might save the government, cost savings alone is not compelling. Okay, and perhaps most importantly, a generalized societal interest in remedying discrimination broadly, as opposed to that specific discrimination by the specific government actor being sued, is not compelling either. And that last one is going to explain a great deal of what happens when we look at the cases where the universities try to justify race conscious admissions policies. Now, I do want to kind of underline the point um, about like let me give you an example. So, like a city government, they cannot justify like a racial preference in hiring or contracting simply because they pointed to a general, undisputed historical fact of discrimination against a racial group in American society, at large. It has to instead point to a specific findings that the particular government actor has itself engaged in that is identifiable discriminatory conduct in the specific area that the remedy targets. And I know that's a lot of words, but I promise it's going to make sense. Um, but that's much more narrow and much more of a demanding showing, okay? And this requirement traces back to a series of cases involving municipal minority set-aside contracting programs in the 1980s and 1990s, I believe, where the cities basically repeatedly attempted, and I should say they repeatedly failed, to justify racial preferences by pointing only to this broad societal pattern of discrimination rather than documented findings that were specific to their own contracting history. Okay. Now consider the narrow tailoring. It's the second half of the test, and it's not going to ask whether the government's goal is legitimate, but whether the specific means chosen are actually necessary to achieve it. Not just helpful, not like a reasonable way to get there, but we're looking at, is it necessary? All right, so courts are going to examine whether a racial classification is over-inclusive, sweeping in people that have nothing to do with the government stated purpose, or is it like under-inclusive and leaving out people who plainly should be covered if the government stated purpose were taken seriously. So courts, they also ask whether the government, seriously considered race-neutral alternatives before reaching for a racial classification at all. Okay, so let me give you an example. Imagine that there is a city government who wants to remedy, that document specific past discrimination in its own municipal contracting process. Okay, a compelling interest, assuming that the city can actually prove that specific history rather than merely asserting it, is necessary. Okay. Now, one approach would be a rigid quota. Exactly 15%, of contracts must go to minority owned firms. Full stop, regardless of individual circumstances. Now, a more narrow approach might instead give qualified minority owned firms um, a a documented history of exclusion, a genuine individualized advantage in a competitive bidding process, while still allowing every firm to compete for every contract. So the first approach guarantees an outcome. The second merely tilts kind of like individualized process. All right, and as you're going to see today, courts consistently favor the second kind of approach and consistently strike down the first. And that's the exact distinction, quota versus individualized consideration that's going to it's going to reappear like almost verbatim when we talk about Gratz and Grutter later. And here's a distinction I want you to also hold on to. Because it's going to organize an enormous amount of the affirmative action material, a policy that treats race as one factor among many, considered individually for each applicant, what the cases will call a quote unquote plus factor, is far more likely to survive the narrow tailoring than a rigid quota. A fixed set of seats or like an automatic point bonus applied mechanically to every member of a group. All right, and we're going to watch that exact distinction decide the outcome of two cases, which are Gratz and Grutter, decided by the same court on the very same day using the very same admission goal at the very same university. Now, I want to introduce what I consider the single most important sentence of this lecture, and it's the idea that will connect every case we discuss today into one continuous doctrinal thread, whether the case is from 1857 or from 2023. Race is treated as what the law calls a suspect classification because of this country's, specific history of using racial classifications to subordinate chattel slavery, Jim Crow segregation, and we're also talking like decades of like de jure discrimination that's enforced by law. And because the government has such a demonstrated historical capacity to misuse racial classification, the courts have decided to treat any government sorting of people by race with the same high level of suspicion, no matter what the government says its purpose is. Okay, so here's the sentence I want you to remember. So in Adirondack construction versus Pena, which was decided, I think in 1995. Yeah, 1995. The Supreme Court held that all racial classifications imposed by the government, whether the government calls them benign, meaning intended to help a racial group, or whether they plainly harm a racial group, are subject to the same exact scrutiny. The same standard applied to Dred Scott era laws that classified enslaved people as property and to the Jim Crow era laws that mandated segregation applies to modern universities' affirmative action admissions policy adopted with the best intentions. All right, now I want you to kind of sit with the implications of that for a moment because it's genuinely counterintuitive to many people encountering this material for the first time. It means that under the current doctrine, courts do not ask whether a racial classification was well intentioned. They do not give a government, a pass simply because its heart was in the right place. All right. Once government sorts people by race for any reason, the courts demand that the government satisfy the same exacting two-part test: compelling interest, narrow tailoring, regardless of whether the classifications was designed to kind of entrench inequality or to remedy it. All right, this is the doctrinal thread that is going to kind of carry us without any real interruption either, from laws that were about racial subordination through the laws that later tried to remedy that same subordination. The constitutional test, formally speaking, never changes. What changes case by case is whether the government manages to satisfy it. And with that said, let's now put our knowledge of scrutiny to the test. This is a case that was widely regarded by legal scholars across the political spectrum as the worst decision of the Supreme Court. All right, Dred Scott versus Sanford, decided in 1857. And this is where our story of citizenship and who the Constitution recognized as entitled to it actually begins. All right, so first I need to tell you about Dred Scott's actual story, because the facts here matter enormously to understanding why the court's decision was so devastating. So Dred Scott was an enslaved man. His owner was an army surgeon named Dr. John Emerson, and he took Scott with him from Missouri, which was a slave state, first to Illinois, which was a free state, and then to the Wisconsin Territory, which was also free under the terms of the Missouri Compromise of 1820, which is a federal statute that had kind of drawn a line across like the remaining territories, and it permitted slavery south of like a certain latitude and then prohibited to the north. And Scott lived on free soil under this arrangement for many years. Now, after Dr. Emerson died, Scott sued for his freedom and the freedom of his family. And he argued that his years under the, of residence on this free soil, it made him a free man. All right. And this was an argument that had actually succeeded for other enslaved people in earlier Missouri cases. And this was under a principle sometimes called like once free, always free. But Scott's case eventually reached federal court on a legal theory called diversity of citizenship, which allows federal courts to hear cases between citizens of different states. But to even get through that courthouse door, Scott first had to establish that he was, in fact, a citizen. And that very question, the Supreme Court would go on to answer in the most gross way possible. Anyhow, but this case, as it reached the Supreme Court, it asked two huge questions. The first one was, can a person of African descent, whether free or enslaved, be a citizen under the United States Constitution? And the second, which was entirely separate, was, did Congress even have the constitutional power to prohibit slavery in the federal territories in the first place? The very power that the Missouri Compromise had relied on. All right, so the court did not need to answer either question narrowly, but it chose to answer both kind of sweepingly, and the answers it gave would help set the country on a direct path toward civil war. Now, Chief Justice Roger Taney wrote the opinion for the majority, and I want to kind of walk you through exactly what he held in stages because I believe that each piece of this did independent damage. Now, first, when it comes to citizenship, Taney held that people of African descent, again, whether enslaved or free, made no difference under his reasoning, were never intended to be included as citizens under the Constitution, and therefore Scott had no legal standing to even bring a lawsuit in federal court in the first place. Now, I want you to read the language that Taney actually used because I think it's important that you hear in his own words rather than a softened paraphrase. Taney wrote that Black Americans had been regarded at the time the Constitution was adopted as, and I'm quoting directly, quoting, beings of an inferior order who had no rights which the white man was bound to respect. That's not my characterization, of the opinion. That's the actual holding of the Supreme Court of the United States in 1857 on the question of who counted as a full person under our founding document. Okay. Second, on congressional power. The court held that Congress lacked any constitutional authority to prohibit slavery in the federal territories at all, and on that basis struck down the Missouri Compromise of 1820 as unconstitutional. Now, I want you to notice how rare that action actually was at the time. This was only the second time that the courts had up to, well, at least up to that point, that it had struck down an act of Congress as unconstitutional. The court was not merely denying one enslaved man his freedom, it was now invalidating the central legislative compromise that had held the country's kind of uneasy truce over slavery together for about 4 decades at this point. Okay. And third, this piece ties directly back to our discussion of the Bill of Rights. The courts held that enslaved people were property under the Fifth Amendment's Due Process Clause, the same clause that protects your own property today from being taken by the government without due process. So, because enslaved people were legally property, Taney reasoned that Congress could not deprive slave owners of that property simply by prohibiting slavery in a territory, those slave owners happened to bring their property into. All right. So notice kind of a grim irony there. You have a constitutional provision that's designed to protect individual liberty was turned by the court into a literal shield for human bondage. Now, let's talk about what this decision actually did to the country because its consequences were immediate and, in the most literal sense, historic. So, Dred Scott actually inflamed sectional tensions over slavery to a very extraordinary degree. And historians will widely credit the decision with hastening, the outbreak of the Civil War just, 4 years later. It closed off any remaining possibility of political compromise on the expansion of slavery into new territories because the court had just declared the entire question constitutionally settled, permanently in favor of slaveholders. So there was, like after Dred Scott, no legislative solution left on the table. You only had, the potential to resort to war. All right. And perhaps the most devastating of all was for the people who were directly affected. It denied every Black American in the country. Didn't matter if they were already free. It didn't matter if they had never spent a single day enslaved. It denied every Black American in the country any claim whatsoever to federal constitutional protection. Okay. Now, here's where I want you to pay especially close attention because this is one of those genuinely rare moments in American constitutional history where the people acting through the amendment process rather than through the court itself directly overruled a Supreme Court decision. The 13th Amendment, ratified in 1865, abolished slavery outright, ending the underlying institution the entire Dred Scott decision had been built to protect. The 14th Amendment, ratified in 1868, the very provision whose text we just talked about, begins its very first sentence with language that directly and unmistakably repudiates Taney's holding. All persons born or naturalized in the United States are citizens of the United States. Congress in the states, through the amendment process, looked directly at what the Supreme Court had said in Dred Scott and wrote it opposite directly into the Constitution. Now, I want you to understand how unusual that is. Dred Scott is only one of a handful of Supreme Court decisions in the entire history of this country that has ever been overturned by constitutional amendment rather than by the court reversing itself in a later case. And that fact alone tells you something important about the limits of judicial supremacy. The idea that the Supreme Court has the final word on constitutional meaning. Sometimes, when the court gets something so catastrophically wrong, the correction does not come from within the judiciary at all. It comes from the people exercising the amendment power that the Constitution itself gives them. Now, slavery ended with the 13th Amendment. Citizenship was constitutionally restored with the 14th, but the underlying question of what genuine racial equality would actually require in practice kind of remained wide open. And in 1896, the Supreme Court answered that question in a way that would govern American life for the next 58 years. And this is Plessy versus Ferguson. And the doctrine it created is separate but equal, and that becomes the law of the land. The facts of Plessy are worth knowing in some detail because this was not an accidental case. It was deliberately engineered as a legal challenge, and understanding that will change how you understand these types of things. So, like in 1890, um, Louisiana passed what is called a Separate Car Act. And it required railroads operating within the state to provide separate railway cars for white and black passengers. Okay. A New Orleans civil rights organization called the Citizens Committee, though it was named in French, it decided to mount this deliberate legal challenge to the law, and they recruited a man named Homer Plessy to test their case. Plessy, by ancestry, was 7/8 white and 1/8 black. Under Louisiana's classification scheme at the time, that made him legally black. Okay. Um, Even though his appearances, he could often, pass as white. All right, so that detail was central to the strategy. So the Citizens Committee wanted a plaintiff whose case would expose exactly how arbitrary and unworkable Louisiana's racial classification scheme was actually in practice. Okay, so Plessy deliberately boarded a whites only railway car, informed the conductor of his racial ancestry, and was arrested when he refused to move to the car that was reserved for black passengers. And he argued that Louisiana's law violated both the 13th Amendment, which abolished slavery, and the 14th Amendment, which guaranteed equal protection. So the case asked the Supreme Court to decide a single enormous question. Does state mandated racial segregation of public facilities violate the Equal Protection Clause? So the court's answer, by a vote of 7-1, was no. And the reasoning it used to get there is kind of worth examining closely because it reveals exactly how a legal system can rationalize profound injustice while using the vocabulary of equality. Okay, so Justice Henry Billings Brown, writing for the majority, held that Louisiana's segregation law did not violate the 14th Amendment so long as the separate facilities provided for each race were, in the law's own terms, equal. All right, this became known as the separate but equal doctrine. The idea that government mandated racial segregation is fully constitutional, provided the government supplies, these equal facilities to each racial group. All right. Now, here's the piece of the court's reasoning that I want you to most kind of think about, because I do think that it's the most revealing part of the entire opinion. The court reasoned that segregation did not, by itself, imply that Black citizens were legally inferior. Okay, and if segregation happened to stamp a quote unquote badge of inferiority on Black Americans, that was the court's own phrase, that was in the majority's view because Black Americans chose to interpret the law that way, not because of anything inherent in the law itself. Like, let that sink in. The court's essentially saying any sense of inferiority you feel from being forcibly separated from white citizens by force of law is a problem with your own perception, not a problem with the law that separated you. Duh. Come on now. I mean, think about it. Um, that move, like locating the harm and perception of the victim rather than in the conduct of the government, is going to echo in different forms throughout constitutional law for decades to come. And in practice, of course, these quote unquote equal facilities, for Black Americans under Jim Crow were almost never actually equal in any meaningful sense. You have underfunded schools, you have inferior rail cars, you have substandard everything. So the doctrine did not require actual equality. It only required the pretense of it. And courts, for nearly 60 years, they largely declined to look too closely behind that pretense. So separate but equal became, in practice, kind of that legal architecture that underpinned the entire Jim Crow system. Now let's talk about this dissent. So against this 7 justice majority stood a single dissenter, and that was Justice John Marshall Harlan. And I want to spend some time on his dissent because it is one of the most influential minority opinions in the entire history of American law, cited approvingly for the rest of the story we're going to tell today. Okay. So Harlan argued that the real purpose of Louisiana's law was not some neutral administrative concern, but a deliberate effort to exclude Black citizens from rail cars that were occupied by white citizens. And that violated both personal liberty and the promise of equal citizenship that the 14th Amendment was written to secure. Now, Harlan wrote the line that outlived every other sentence in this case. And it's the line that I suspect that many of you may have already heard somewhere, perhaps without even knowing its source. And that is, our Constitution is colorblind and neither knows nor tolerates classes among citizens. Okay. Harlan did something else in his dissent that I also think is amazing. Um, he explicitly compared the majority's reasoning to Dred Scott, the case that we just talked about, and he warned that history would judge Plessy just as harshly as it already judged Dred Scott. And he turned out to be exactly right. Plessy is remembered today alongside Dred Scott as one of the court's greatest moral failures, and Harlan's dissent is remembered as prophetic. Okay, now I want to point something out to you before we move on, because intellectual honesty does require it. Now, Harlan's vision of a colorblind constitution has become enormously influential. Like, it was cited approvingly in Brown versus Board of Education, which we're going to talk about next. And it was invoked, on both sides of the affirmative action debate. And you're going to hear echoes of Harlan's language throughout, like later when I talk about Chief Justice Roberts' majority opinion in the Harvard case, which cites the colorblind principle to strike down race-conscious admissions. You're going to hear it in Gruder's, defenders when they argue that Harlan's vision was aspirational, describing where the Constitution should eventually arrive, rather than, this doctrinal command that is going to shut down any government use of race along the way, including race conscious remedies meant to help. But I also want you to know that Harlan's opinion in the same dissent does contain deeply racist language about Chinese immigrants. And this is important and uncomfortable reminder that even celebrated dissents are products of their historical moment, written by flawed people, not like these moral abstractions handed down, from the high, right? You can recognize the enduring power of, quote, our Constitution is colorblind, while also recognizing that the man who wrote it held views on other questions that we would rightfully condemn today. Now, Plessy did not create Jim Crow segregation on its own. Much of it already existed in practice before 1896, but it gave that entire system constitutional cover, legitimizing government mandated racial segregation across the American South and its various forms beyond it in schools and transportation, housing, public accommodations, all of those things for nearly 6 decades. All right. So it's applied what I would describe as the constitutional, you know, architecture for Jim Crow. You have this comprehensive regime of racial subordination that's enforced not merely through law, but through custom. And when custom proved insufficient, through violence. All right, so the specifics are worth naming because Jim Crow can otherwise remain abstract. All right, separate rail cars, exactly like the one at issue in Plessy itself. Separate schools, chronically underfunded relative to their white counterparts, which is precisely like the disparity that the plaintiffs in Brown would eventually put before the court with hard evidence. Separate water fountains, separate waiting rooms, separate entrances to the same building, the laws restricting where Black citizens could live, who they could marry, and in what states, whether how they could vote at all, notwithstanding the 15th Amendment's explicit textual guarantee. And it stood as binding, controlling precedent cited by courts across the country until 1954, when the Supreme Court finally confronted, this directly in Brown versus Board of Education and held unanimously that separate is inherently unequal. All right, at least in the specific context of public education. Now, 58 years after Plessy blessed segregation, the Supreme Court reversed course unanimously in Brown versus Board of Education. And this is arguably the single most important equal protection decision of the 20th century. And I want us to spend some time kind of understanding not just what it held, but how carefully it was built and how incompletely it was enforced in the end. So Brown versus Board of Education of Topeka was not actually a single case. It was 5 separate cases that were consolidated by the Supreme Court, and they came from Kansas, South Carolina, Virginia, Delaware, and the District of Columbia, each one challenging racially segregated public schools in its own jurisdiction. Now, the litigation strategy behind Brown was the product of decades of careful, deliberate work by the NAACP, their legal defense fund, specifically led by a young lawyer named Thurgood Marshall, who would go on, like 13 years later, to become the first Black justice ever appointed to the Supreme Court that he was, at this particular moment, arguing in front of. Now, the plaintiff's legal argument rested on something genuinely novel for its time. Okay, so alongside traditional legal argument, they introduced social science evidence directly into the litigation. Most famously, the research of psychologists Kenneth and Mamie Clark, whose so-called, doll studies asked Black children to choose between white dolls and black dolls and to assign positive and negative characteristics to each. So the Clark's research suggested that segregation itself inflicted genuine psychological harm on Black children. There was a sense of inferiority that was instilled, not by any inherent differences between the race, but by the simple fact of being legally separated. All right, so that evidence was central to the plaintiff's argument that separate could never, in practice, be truly equal. So the consolidated cases plainly asked the Supreme Court to reconsider Plessy's separate but equal doctrine, specifically in the context of public education, which was a context that Plessy itself had never actually addressed since the earlier case involved railway cars and not schools. Now, Chief Justice Earl Warren wrote the opinion, and I want you to notice something remarkable about it before, like, we even get to its substance. It was unanimous, 9-0. Like, Warren had worked deliberately behind the scenes to bring this fractured court together into a single, unified opinion, believing correctly that a decision this consequential needed to speak with one voice rather than arrive as a fragmented set of separate opinions that might invite some continued resistance. Okay. Now, the holding, in Warren's own words, because I think kind of the plain force of the sentence deserves to be heard directly. He said, "We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." All right, so notice what that sentence does. It's not simply saying that Kansas's, their particular schools happen to be unequal in that particular instance, like requiring a factual inquiry into whether, like, the buildings, are good. Are the textbooks comparable? What about the teachers' salaries, right? It says something categorically different, that separation itself, once imposed by law on the basis of race, produces inequality inherently by its very nature, regardless of how carefully the government tries to equalize, the tangible resources on each side of the spectrum here. Okay, so the court's reasoning centers on this unique role of public education in American life. Education, Warren said, is a fundamental function of state and local government, and segregated schools generate a sense of inferiority in Black children that affects their motivation to learn. And it's a psychological harm that persists regardless of whether school buildings, textbooks, or teacher qualifications happen to be equal on paper. This is where the Clark doll studies, kind of did their real work, giving the court an evidentiary basis for exactly the kind of inherent harm that Plessy's majority had, dismissed as, merely a matter of subjective perception 60 years earlier. Now, Brown explicitly overruled Plessy, at least within the context of public education. kind of rejecting once and for all, like the notion that separate facilities can never be genuinely equal once race has been legally set apart from one another. But notice what the court deliberately did not do in this first opinion. It did not decide how or how quickly segregated school systems actually had to desegregate. That became this enormous practical question, the question of remedy, got deferred to a second decision the following year. So in Brown Part 2, which was decided in 1955, it addressed exactly that deferred question. And I want you to pay attention to the specific language that the court chose, because that language would go on to shape and in many ways kind of undermine the practical impact of Brown for more than a decade. The court remanded the consolidated cases to the federal district courts that had originally heard them, instructing those courts to require that students be admitted to public schools on a racially non-discriminatory basis, but with a crucial and famously ambiguous qualifier, and that was, quote unquote, with all deliberate speed. The court set no firm nationwide deadline. It left substantial discretion to the local school boards and to the district court supervising them, which was a compromise the court intended as a kind of pragmatic accommodation to the anticipated intensity of resistance in the South. But in practice, all deliberate speed became something close to a substitution for the word delay. Okay. Many Southern school districts resisted meaningful desegregation for years, and in some cases for well over a decade. And through legal maneuvering, outright defiance, and occasionally like open political confrontation, there was, required, we had to have like extensive additional litigation and eventually direct federal enforcement in order to make this happen. So the most famous single episode came in 1957 when President Eisenhower deployed federal troops to Little Rock, Arkansas, to physically escort 9 Black students into Central High School over the explicit opposition of the state's governor. Brown had declared the constitutional right, but actually securing the right on the ground in real schools took a decade of additional struggle. Now, Brown stands as the single most significant equal protection decision of the 20th century, in my opinion. It delegitimized de jure segregation as a matter of constitutional law and became the catalyst, for broader modern civil rights movements that would, over the following decade, produce the Civil Rights Act of 1964, which we're going to talk about. But it also produced the Voting Rights Act of 1965. Brown established as a foundational constitutional principle that separate but equal is never truly equal when the separation in question is imposed on the basis of race by government action. All right, but I want you to kind of take one lesson forward from this, because it does matter enormously when we talk about these later cases. Brown, the second case, the use of all deliberate speed remedy, it became something of a cautionary tale in constitutional law, a case study in the gap that can open between declaring a right in a unanimous, forcefully worded opinion and actually enforcing that right in the world. So kind of keep that gap in mind, because it is something that the court will repeatedly wrestle with when it comes to these additional questions, like what does an adequate remedy for past discrimination actually look like, once the underlying wrong has been declared unconstitutional. So now we're going to shift into a new phase of the story entirely. 2 decades after Brown finally tore down this legally mandated segregation, a genuinely different question reached the Supreme Court. And it was one that Brown itself never had to confront. And that was, can the government use race to exclude a racial group and not merely to remedy a specific identified instance of its own past discrimination, but affirmatively to help build a more diverse institution going forward? Okay. And critically, like, does the same scrutiny or strict scrutiny standard that we talked about, like the standard originally forged to kind of strike down the laws that subordinated Black Americans, still apply with full force to laws that are trying to do the opposite? Okay. And we kind of already previewed the answer through Adirondack. Um, but yes, it does without exception. What we have not yet seen is how the answer actually plays out when real universities try to build real admissions policies around race. And that's where we go now. Now, before we reach the two cases that we have for this section, I want to spend a little bit of time on a case that is not technically like on your reading list or anything like that, but it's the Regents of University of California versus Bakke, which was decided in 1978. Think of Baki as the kind of essential bridge connecting Brown to the entire like modern affirmative action story. The case that first established, the doctrinal framework that every later case is going to either apply, refine, or ultimately dismantle. But here are the facts. So the University of California, Davis Medical School. It operated two separate admission tracks. Um, of the 100 seats of each entering class, 16 were specifically reserved for disadvantaged or minority applicants. They were evaluated through a completely separate admissions process from the regular, applicant pool. So Alan Bakke was a white applicant and he applied twice and was rejected both times, despite having what he argued were stronger objective qualifications, higher grades, higher test scores, than some of these other applicants that were admitted through the special 16-seat track. And Bakke sued. He argued that this arrangement amounted to unconstitutional racial discrimination against him. Now, the Supreme Court's decision in Bakke was genuinely fractured, okay? There was no single majority opinion that commanded 5 votes on every point, which is why part of the case can feel confusing at first. You have 4 justices who would have upheld Davis's set aside program kind of entirely, reasoning that a university may permissibly use race to remedy the effects of societal discrimination more broadly. You have 4 other justices who would have struck down the program entirely and, would have avoided the constitutional question altogether by resolving the case on statutory grounds under Title VI, reasoning that race should essentially never be considered in this context. So, Justice Powell, he kind of occupied the decisive middle position alone. Okay. And because his was the narrowest opinion that was necessary to produce a judgment, the later courts have generally treated his reasoning rather than either, the other justices' reasoning as controlling. Okay. And it's worth kind of like pausing on because it does really kind of show how the Supreme Court actually operates. You got a single justice writing alone without a full majority behind every single sentence of his reasoning, and it can still end up being, the rule of law that governs. And in this case, it was for the next 25 years of litigation simply because his was the position that could actually command a judgment in the case. Um, Powell held that rigid racial quotas, a fixed number of seats set aside for a particular racial group, kind of walled off from the competition, with the rest of the applicant pool, exactly like this 16-seat track was, are unconstitutional. But Powell also held that race could still be considered as one factor among many in a genuinely individualized, holistic review of each applicant's complete file. because achieving a diverse student body is, in Powell's view, a compelling interest, specifically for institutions of higher education. Now, I want you to kind of notice how, narrow and how consequential that distinction kind of turned out to be. A quota, the walling off of a fixed number of seats by race is unconstitutional. But race as one factor, weighed individually alongside, every other factor in an applicant's file without guarantee of a numerical outcome, what he called a quote unquote plus factor, could survive. Now, Bakke had no single controlling majority opinion, but Powell's diversity rationale and his race as a plus factor framework became the doctrinal foundation that the court would revisit and ultimately would really kind of dig in and apply with some real teeth in the next two cases that we're going to talk about, which were decided exactly 25 years later on the very same day involving the very same university. Now we're going to start with Gratz versus Bollinger, and it was decided in 2003. And this case involves a 150-point admission index and a flat automatic 20-point bonus awarded to every applicant from an underrepresented minority group. So as we're about to see, this case was decided on the very same day as its companion case, which is Grutter, and it reached the opposite result. All right, so the University of Michigan's undergraduate admissions at the time that this case came up, they used that 150-point selection index to evaluate the applicants. And roughly 100 points out of that possible 150 were generally sufficient in order for you to get in. Okay, now here's the part that would prove fatal to the policy. Under the index, any applicant that belonged to what the university defined as an underrepresented minority group, specifically African American, Hispanic, or Native, those applicants automatically received 20 points simply by virtue of checking this box. Okay, there was no individualized review of the applicant's file that was required. Now, think about that for a second, how large that number actually was in context, because 20 points out of the roughly 100 needed for admission represented 1/5 everything that an applicant needed to get into the door. Now, by comparison, and this comparison is exactly what caught the court's attention, a perfect SAT score was worth only 12 points under that same index. Okay, and an outstanding, like exceptionally well-written personal essay was worth at most 3 points. Okay, so race, in other words, was worth roughly about 7 times as much as this individualized personal component, their personal essay, and almost double the perfect standardized score. All right, so Jennifer Gratz and Patrick Hamaker, they were two white applicants who were denied admission, and they sued, arguing that this point system violated the Equal Protection Clause and Title VI of the Civil Rights Act of 1964, which was a statutory provision closely related to Title VII, which we're going to talk about, but it prohibits race discrimination in any program receiving federal funding. So Chief Justice Rehnquist wrote for the majority, and the court struck down the point system, holding that it was not narrowly tailored to achieve the university's stated compelling interest in diversity, even though the court accepted, following Bakke, that diversity itself could be a legitimate compelling interest for a university to pursue. Now, here's the core of the court's reasoning, and I want you to see how it kind of goes back to that narrow tailoring idea. The automatic 20-point racial bonus effectively made race a decisive factor for virtually every, minimally qualified applicant from an underrepresented minority group. All right. The system provided no individualized, like holistic review of any applicant's complete file. And remember, individualized holistic review was precisely what Justice Powell's opinion in Bakke had required in order for race to function as a legitimate plus factor rather than an impermissible quota. So because this point system, functioned in a practical effect, essentially like a quota, kind of guaranteeing a particular outcome for a defined category of applicants, rather than genuinely like informing an individualized judgment about each one. It failed strict scrutiny's narrow tailoring requirement. The interest in diversity itself might have been compelling, but the means chosen to pursue it were not narrowly tailored. Now let's talk about Grutter versus Bollinger, which was decided the exact same day as Graz, and it's involving the exact same, university's law school rather than its undergraduate program. Now here, holistic, individualized review of race in pursuit of what the university called a critical mass of diversity survived strict scrutiny. Same day, same university, same underlying goal, but as we're going to see, it has the opposite result. So, this is the University of Michigan, but it's their law school. And unlike its undergraduate admissions office, they used a genuinely holistic admissions policy, considering race as one factor among many others, like grades, standardized test scores, personal essays, letters of recommendation, and whatever else they added. But they were all evaluated together for each applicant rather than, run through like any kind of, point system. Okay. The law school's stated goal was to enroll what it called a critical mass of underrepresented minority students, a number that was considered sufficient in the university's judgment to secure genuine educational benefits that come from meaningful diversity in the classroom, such as breaking down, racial stereotypes and enabling students of all backgrounds to learn from each other's varied perspectives. Now, notice deliberately what the law school did not do. It did not set a fixed number or a fixed percentage of seats reserved for any racial group. Critical mass was framed as a qualitative educational judgment and not a specific numerical target. Okay. So Barbara Grutter, not Grutter, by the way, it's Grutter, a white applicant with a 3.8 GPA for her undergrad and a 161 on the LSAT, which is amazing. She is a genuinely strong applicant by conventional measure. She was denied admission and sued, arguing that the law school's consideration of race amounted to unconstitutional racial discrimination against her. And that case reached the law school's more you know, individualized admissions process in direct contrast to the undergraduate case that we just talked about in Graz. Now, Justice Sandra Day O'Connor, she wrote for a narrow 5-4 majority, and this time the court upheld the policy, expressly adopting Justice Powell's controlling opinion from Bakke as the governing rule 25 years after Powell first wrote it. Student body diversity, O'Connor said, is a compelling interest for institutions of higher education, and the law school's admissions policy was narrowly tailored to serve it. So, why did this policy survive where the undergraduate point system in Graz did not? Um, it's because the law school engaged in genuinely individualized holistic review. Race was just one factor that was considered among many. They didn't have fixed quotas. There was no separate, admissions track that was, walled off from the rest of the applicant pool. And you had meaningful, individualized consideration that was given to every single applicant's complete file, which was exactly the feature that, had kind of been absent from the Gratz case with the undergraduate point system. So the court also did impose an important relatable, or not relatable, but related requirement here. And that was universities pursuing these race conscious admissions. They have to give serious good faith consideration to workable race neutral alternatives before turning to race at all. Okay. Um, but, and this distinction does matter because it's going to come under direct pressure in Fisher. which was like a decade later. But the court did not require universities to exhaust like literally every conceivable race neutral alternative before considering race. Just good faith consideration, not an exhaustive search. That was the standard. Okay. Now, I want to close on this with a line from O'Connor's opinion that has become one of the most consequential sentences in the entire body of affirmative action law because it planted the seed that would grow into the ending of today's lecture. O'Connor wrote, "We expect that 25 years from now, the use of racial preferences will no longer be necessary." Now, do the math along with me for a minute. Grutter was decided in 2023. 25 years later lands us at 2028. We're not there yet, but keep that number in the back of your mind because as we move into part 3, you're going to watch the Supreme Court arrive at something very close to that endpoint, maybe considerably ahead of O'Connor's kind of informal, schedule. But I want you to also know that Grutter was genuinely contested, 5-4 decision, and the dissenting justices were Rehnquist, Scalia, Kennedy, and Thomas. And they raised objections worth understanding because several of those same objections would resurface 20 years later as the majority position in the Harvard case that we're going to talk about. Justice Thomas, in particular, wrote a very lengthy separate dissent arguing that the law school's critical mass concept was functionally indistinguishable from an unconstitutional quota dressed up in vague language, and that this entire diversity rationale rested on assumptions about educational value of racial diversity that the Constitution does not require courts to simply accept on faith. So kind of sitting with those dissenting arguments now, it hopefully will make, the next part easier to follow because you'll at least already recognize the seeds that have been planted in this position that's going to eventually prevail. Now, I want to pause here and put these two cases directly side by side because I think the comparison teaches narrow tailoring more effectively than either case does standing alone. In Gratz, the undergraduate program that the court, confronted this 150-point index, right? With this automatic 20-point racial bonus, no individualized file review for any applicant, race functioning as an effectively decisive factor for the relevant group of applicants. And the result was that the policy was struck down. In Grutter, the law school, the court confronted holistic, genuinely individualized review, a critical mass goal rather than a fixed quota, a full file review conducted for every single applicant, and race treated as one factor considered among many rather than this, just this trump card that's going to give them this additional 20 points. And the result was that the policy was upheld. Again, same university, same underlying educational goal, which was building a diverse student body, same day of decision, handed down by the same 9 justices, and entirely two opposite constitutional outcomes, turning entirely on kind of the mechanics of implementation rather than on the underlying goal itself. This is narrow tailoring in kind of its purest, most concentrated form. It's not enough for the government's goal to be compelling. The specific means chosen to reach that goal have to actually satisfy the doctrine's structural requirements, which is individualized, not mechanical, which is a factor among many, not a guaranteed outcome. Now we move to part 3, and this is into the 21st century's second major chapter in kind of the affirmative action story. 10 years after Grutter, the court takes up Fisher versus the University of Texas, which was decided in 2013, and it's a case that we refer to as Fisher 1, because as you're about to see, the same fact pattern is going to return to the court a second time 3 years later. Now, I want to tell you up front what this case does and does not do, because it's easy to kind of misread. The court does not overrule Grutter here. What it does is insist very forcefully that lower courts stop deferring to universities when they evaluate whether a race conscious admissions policy is actually narrowly tailored. That distinction between the goals and the means and how much deference courts owe to each is basically the entire lesson of Fisher 1. Now, Texas had developed its own distinctive path to campus diversity, and it's one worth understanding on its own terms before we actually get to the litigation. Now, under what the state calls its top 10% plan, any student graduating in the top 10% of their high school class is automatically admitted to any public university in Texas, including the flagship campus at Austin, regardless of their race. Plan says nothing about race at all on its face. Now, because Texas's public schools, or high schools rather, we should say, they remain kind of in practice quite like racially segregated um, through their neighborhood, demographics. This facially race neutral plan actually produces meaningful racial diversity as an indirect consequence, since the top students from predominantly Black and Hispanic high schools are guaranteed admission alongside top students from predominantly white ones. So this top 10% plan filled roughly 75% of the University of Texas at Austin's incoming class. Now, for the remaining 25% of seats, the university layered a separate holistic review process on top of the plan. And this is a process that modeled, closely on the one that Grutter had approved for the University of Michigan's law school, considering race as one factor among many for applicants who fell outside of the automatic top 10% guarantee. Now, Abigail Fisher, a white applicant who did not qualify under the top 10% plan and who was denied admission through this secondary holistic, review process, sued, arguing that the university's consideration of race in that holistic layer violated the Equal Protection Clause. Now, the lower appellate court, which was the Fifth Circuit, they had sided with the university, giving substantial deference to the university's own good faith judgment about how best to achieve its diversity goals, which was exactly the kind of judicial deference the Supreme Court was about to say was inappropriate. So Justice Anthony Kennedy wrote for the court that was nearly unanimous. You have only Justice Ginsburg dissenting, but you also have Justice Kagan, who recused from the case entirely because of her earlier work on it as Solicitor General. Now, the court held that the Fifth Circuit had applied strict scrutiny far too deferentially, and it vacated the lower court's decision and sent the case back down for a second look under a considerably more demanding standard. Now, here is the precise, like carefully drawn distinction that Kennedy's opinion establishes, and I want you to kind of hold on to it because this is like the core of Fisher 1. Courts may defer to a university's own good faith academic judgment that diversity is a compelling educational goal that's worth pursuing. Universities, they have genuine institutional expertise about what produces a good educational environment, and courts have generally been willing to respect that expertise on the question of goals. But courts may not defer to a university's own judgment about whether the specific means it has chosen to pursue that goal are actually narrowly tailored. So, on that second question, the means, not the ends, the university bears the full burden of proof, okay, with like no judicial thumb on the scale here in its favor, right? It has to demonstrate that workable race neutral alternatives genuinely could not produce comparable educational benefits of diversity. So I want you to kind of notice how cleanly that tracks that two-part strict scrutiny test, okay? The compelling interest, the narrow tailoring. So Fisher 1 is essentially telling lower courts, look, you can go easy on the universities regarding the first half of that test, but you have to go hard on universities regarding that second half, okay? The court vacated and remanded for the Fifth Circuit to apply this considerably more rigorous version of strict scrutiny. But I do want to stress, like one more time, that when Fisher won, and what it has not done, again, it did not overrule Grutter. It did not overrule Baki's, underlying diversity rationale. Race conscious admissions done correctly, they remained fully constitutional after Fisher won. What changed was how skeptically courts were now required to scrutinize the quote unquote done correctly part. Now, on remand, under this newly demanding standard, the very same University of Texas admission policy came back before the Supreme Court a second time. Fisher versus University of Texas decided in 2016, which we're going to call Fisher 2. Okay. This turns out to be the last major victory for race conscious admissions before the whole thing comes apart 7 years later. Now, the same University of Texas admissions policy from Fisher 1 was now evaluated by the lower courts under these considerably stricter, non-deferential standards that the Supreme Court had just announced. This time, in a 4-3 decision, again with Justice Kagan recused, Justice Kennedy, writing for the majority, held that the university had actually met its demanding burden. But what tipped the balance? Okay. The university presented specific concrete evidence, including like empirical studies showing that meaningful racial isolation persisted at the individual classroom level, even under the top 10%, substantial numerical diversity at the institution-wide level. In other words, the university could show that with real data, rather than just assertion, that even though the freshman class as a whole looked reasonably diverse thanks to the top 10% plan, many individual classrooms within that same freshman class remained functionally segregated in practice, with few or no minority students present in a given section. That specific kind of granular evidence persuaded the court that a purely race neutral mechanism, the top 10% plan, kind of on its own, was not, in fact, adequately achieving the educational benefits of diversity that Grutter had recognized as compelling, and that the additional limited holistic consideration of race for the remaining seats was therefore genuinely necessary, not just merely convenient. So the court affirmed the university's policy as constitutional, holding that it was narrowly tailored to the university's compelling interest in diversity. So let's kind of break down what Fisher 1 and Fisher 2, when taken together, actually established as governing law, because I want you to kind of walk away with these three principles, at least in some sort of form that you can recite from memory. First is that strict scrutiny always applies. Any government use of race, including a use explicitly intended to promote diversity, even for benign purposes, is subject to strict scrutiny without exception. Okay. And we built this principle all the way back in part 1 through Adirond, and it has not moved a single inch through any of these cases that we've studied since. Second is that courts may defer to a university's reasoned, good faith judgment that diversity itself is compelling, in terms of educational interest. This is the piece of the test where the universities are going to retain some genuine institutional latitude. Courts are not going to second guess a university's, judgment that a diverse student body produces real educational value. Third is the piece that Fisher 1 specifically tightened. And it basically is that there is no deference whatsoever on narrow tailoring. The university bears the full burden, okay, unaided by any judicial presumption in its favor, proving that the race neutral alternatives genuinely could not achieve comparable educational benefits. Fisher 2 shows you what it actually looks like for a university to carry that burden successfully with real evidence, okay? But I want you to notice, kind of looking ahead, that this was just kind of a razor thin, 4-3 victory. is decided under a version of strict scrutiny that had just become considerably more demanding. So the margin for error by 2016 had grown very thin. We now arrive at a case that represents the controlling law currently in this entire area, and it's the Student for Fair Admissions versus Harvard, which was decided in 2023. This case is not technically like one of the um, cases that I've given you for like reading, but I do think it's considered, I do consider it essential because it's the decision that overtook Grutter. It overtook Fisher 1 and Fisher 2 all at once. Okay. And it's the law that you would actually need to apply if a client walked into your office tomorrow with a question about race conscious admissions. So, Students for Fair Admissions is an organization representing a group of Asian American applicants, and they sued both Harvard and the University of North Carolina simultaneously in a pair of companion cases that were decided together, alleging that the university's race conscious admissions programs discriminated specifically against Asian American applicants in violation of equal protection, and with respect to Harvard as a private institution receiving federal funding, which is goes back to the Title VI of the Civil Rights Act. Now, I want you to notice something about the plaintiffs here because it complicates the simple story some people tell about affirmative action litigation. This was not white applicants alleging discrimination in favor of Black and Hispanic applicants, which was the fact pattern that you saw in Bakke, Gratz, Grutter, and Fisher. This was an organization representing Asian American applicants, arguing that Harvard's holistic review process was systematically disadvantaging them relative to other racial groups. Again, it's through these mechanisms like consistently lower personal ratings that were assigned to Asian American applicants by admissions officers, ratings, the plaintiffs argued reflected racial stereotyping rather than genuine individual assessment. Now, the trial record in this case developed over years of litigation before it actually reached the Supreme Court. And it's worth understanding in kind of a bit more detail because it really did shape how the majority ultimately framed its opinion. Statistical experts for the plaintiffs presented regression analysis showing, that Asian American applicants on average needed to outperform applicants of other races on objective measures like academic and extracurricular ratings in order to achieve comparable admission rates. And that these Asian American applicants specifically scored lower on average on Harvard's own internal personal rating, which was a subjective assessment of qualities like likability and courage than other racial groups, despite like not scoring lower on personal ratings assigned by outside alumni interviewers who actually met the applicants in person. That specific discrepancy, which was a subjective file-based rating that's produced by admission staff who never actually met the applicant, kind of diverging sharply from this in-person rating system that was produced by somebody who did, became one of the most closely scrutinized pieces of evidence in the entire case, and it fed directly into the majority's broader skepticism about whether holistic review, as actually practiced, was functioning as a neutral, individualized process, or was it just being used as a means for stereotyping? So both universities used holistic review processes modeled directly on the Bakke and Grutter framework that we already talked about, race as one factor among many considered individually for each applicant. The case very plainly asked the Supreme Court to revisit whether Grutter's diversity rationale remained good law nearly 20 years after it was decided, arriving very notably right around that informal 25-year window that Justice O'Connor herself had, kind of put into the Grutter opinion. Now, Chief Justice Roberts wrote for the majority which was 6-2 with respect to Harvard, since Justice Jackson recused herself from that particular case because of her prior service on Harvard's, Board of Overseers, and 6-3 with respect to the University of North Carolina, where she did participate. The court held that both universities' race conscious admissions programs violate the Equal Protection Clause. So, Robert identified 3 specific fatal flaws in those programs. And I want you to notice that every single one of those flaws traces directly back to language and reasoning found within Gruder's own framework. So the court is not like on its own telling, like inventing a brand new standard. It's holding that these particular programs fail even the standard Gruder itself established. Okay. Um, First, the university stated diversity interests. They were not measurable in any way that a reviewing court could meaningfully evaluate. So you have these vague aspirational goals like a robust exchange of ideas, or the educational benefits that flow from a diverse student body. The majority reasoned you just simply cannot, this can't be assessed with the same like judicial rigor that strict scrutiny demands. So if a court cannot tell what would even count as achieving the university's stated goal, how could that court ever determine like whether the university's chosen means are actually necessary to reach it? All right. Second, in a genuinely zero sum admissions policy where one applicant's acceptance necessarily means another applicant's rejection, since there can only be so many seats, the court held that race was in practice being used as a negative factor. And it was effectively, kind of functioning as a stereotype that was applied against some applicants, which was exactly the kind of like racial pigeonholing that the Equal Protection Clause had always been the most suspicious of, going all the way back to the cases we talked about at the very beginning. Um, Third, and this is the piece that I find, most directly connected back to Gruder's own words, is that the programs lacked any logical, meaningful endpoint, meaning O'Connor's 25-year expectations from Gruder itself, the assumption built directly into that earlier opinion that race conscious admissions would eventually become unnecessary. Well, in this particular case, the Students for Fair Admission majority essentially held that Harvard and the University of North Carolina to that promise, and found neither university had articulated any kind of coherent plan for how or when its own race conscious policy would ever end. Justice Thomas, in a very, very lengthy separate concurrence, he went further than the majority opinion itself, was kind of willing to go. And he explicitly stated very I mean, like plainly, Gruder is, for all intents and purposes, overruled. And I want you to notice something genuinely interesting here. Justice Sotomayor's dissent, despite obviously disagreeing with the outcome, agreed with Thomas's blunt characterization of what the majority's opinions, like their practical effect was, even while the majority opinion itself carefully avoided to use the word overruled. Okay. Um, and I also want to point out, one little like piece that the court preserved, because I think it matters enormously for how admissions offices actually had to redesign their practices going forward. So applicants may still discuss, like in their own personal essays, how their individual racial backgrounds have shaped their character, their experiences, or like, specific challenges that they have personally overcome. But what a university may no longer do is use an applicant's race as a factor in the admissions decision itself. So the distinction, as we're about to discuss, is genuinely different to administer cleanly in practice. Okay. And the strongest version of the dissenting opinion, because a fair understanding of this case kind of requires it, Justice Sotomayor was joined by Justices Kagan and Jackson in relevant part, and they argued that the majority's decision kind of rolled back decades of progress toward racial equality in higher education, and that it did so by holding race-conscious admissions to a standard of precision, a perfectly measurable goal, a perfectly logical endpoint. that the court has never actually demanded of any other compelling interest in any other area of constitutional law. And the dissent argued that the majority's professed adherence to this colorblind constitution ignored the very real ongoing effects of centuries of race conscious subordination, which was the entire history that we started out with, right? And that declaring the Constitution colorblind today, after that history, does not erase the present day consequences of that history. All right. It is simply one of the tools that had been available to address them, and now it's not. So, whatever your own view of the outcome, you should at least be able to state this dissenting position as persuasively as the authors intended it, because it is what genuine legal analysis does require. Now let's take an honest inventory of exactly what survived this decision and what did not, because precision matters. For anybody who might end up advising a client or a university on this exact question, effectively overruled race as a plus factor within that holistic review. The central mechanism of Grutter itself approved this, and Fisher went on to uphold it. It no longer survives. Okay. The critical mass diversity rationale, standing on its own as a compelling interest that's sufficient to, justify race conscious admissions, no longer survives. Judicial deference to a university's own definition of its diversity goals. Even the narrow goal only deference that Fisher one had preserved, it's gone. The court upheld, or held that those goals were never measurable enough to be entitled to deference in the first place. Now, still permitted. I want you to kind of notice how much of this directly echoes kind of the Texas top 10% plan that we talked about. Race neutral proxies for diversity remain fully available. Factors like socioeconomic status, your first generation college status, geography, all of which correlate with racial diversity without directly classifying any individual applicant by race. The discussion of how race has shaped an individual applicant's personal character or experience remains permitted so long as it is genuinely treated as an element of that applicant's individual story rather than like this box that you check for, group membership. And one more detail, because it is a live unresolved question. The majority opinion in a footnote explicitly left open the question of whether military service academies might be subject to a different analysis given the distinct national security interests the government argued were at stake. And that's an unresolved question that the court is simply, they declined to decide in this particular case. But in the years that were following this decision, universities across the country quickly moved to redesign their admissions practices around exactly this surviving versus overruled line, right? So many institutions expanded the weight given to essay prompts, inviting, the applicants to discuss personal adversity, family background, community context, without directly asking about race. Others increased their reliance on the kind of race neutral proxies that dramatically kind of expanded recruitment efforts targeting the under-resourced high schools and first generation applicants rather than racial categories directly. Now, whether those redesigned practices, actually produce diversity outcomes that are comparable to what the prior holistic frameworks, achieved, it kind of remains genuinely contested question, but it's still one that's being studied and litigated and debated, kind of as we speak. Now, for the remainder of this lecture, we're going to do something different. Everything so far, Dred Scott, Plessy, Brown, Bakke, Gratz, Grutter, Fisher, SFFA, has involved the Equal Protection Clause of the 14th Amendment, which is a constitutional provision that, as we established at the very beginning of today's lecture, restrains the government action specifically. But for our final part, I want to move to the from the Constitution to the United States Code, specifically Title VII of the Civil Rights Act of 1964, The federal statute that governs discrimination in employment. I want you to pay close attention here because the rules genuinely change once we leave constitutional law and enter statutory law. And understanding exactly why they change and how is the whole point of this final section. So let's talk about the basic architecture of the statute. Title VII of the Civil Rights Act of 1964 prohibits employment discrimination on the basis of race, color, religion, sex, and national origin. It applies to private employers and public employers alike, so long as they employ 15 or more people. And it also covers employment agencies and labor unions. The statute reaches essentially every meaningful stage of the employment relationship, like the hiring, the firing, the compensation, promotion, and any other kind of broader terms and conditions of employment. Now, Title VII is enforced by the Equal Employment Opportunity Commission, commonly called the EEOC. And it's a federal administrative agency that investigates discrimination charges filed by employees and can bring lawsuits or authorize private lawsuits against employers who have found, who they found, I guess, to have violated a statute. So if you go on to work in employment law, like in human resources compliance or really any kind of area of civil litigation, you're very likely to encounter the EEOC's administrative process directly, because in most cases, an employee cannot simply walk into federal court and sue their employer under Title VII. They generally must file a charge with the EEOC and allow the agency an opportunity to investigate and potentially mediate the dispute and receive what is called a right to sue letter before litigation can proceed in court. Now, this administrative exhaustion requirement serves a real practical purpose. It gives the EEOC a chance to resolve the disputes without full-blown litigation, and it creates an early administrative record that can prove very valuable to either case, either side, once the case does proceed to court. I guess I should say if it proceeds to court. Um, but here is the single most important thing on this slide. It's the one thing I want you to remember. Title VII is a federal statute. It was passed by Congress in 1964. It's not a constitutional provision. It did not come from the 14th Amendment. It is not subject to the 14th Amendment's own internal rules about what a plaintiff must prove. And that distinction, which might sound technical at first, turns out to matter enormously for what an employee actually has to demonstrate in order to win a discrimination case. And we're about to see why. So Title VII recognizes two genuinely distinct legal theories under which an employee can establish unlawful discrimination. I want you to understand them both clearly because they require completely different kinds of proof, and mixing them up is one of the most common mistakes that students do make. But the first theory is the disparate treatment. That is intentional discrimination, meaning an employer treated a particular employee differently and in some concrete way, specifically because of that employee's race or another characteristic the statute, protects. This theory requires proof of discriminatory intent or motive on the part of the employer. Because direct evidence of that intent is genuinely very rare, very few employers put, I'm firing you because of your race, like in writing, or like in an email or a personnel file, because they know that an employee's lawyer is going to discover that during discovery. The Supreme Court developed a specific structured framework called the McDonnell-Douglas burden shifting framework. And it's to help courts and juries to evaluate circumstantial evidence of intent. And we're going to talk about that in just a minute. But a classic disparate treatment example would be an employer who refuses to hire or who fires an employee explicitly because of that employee's race. Now, the second theory is the disparate impact. And this is the theory that I want you to most focus on because it's going to reveal kind of the biggest doctrinal difference between constitutional and statutory discrimination laws. Disparate impact involves a policy that is completely neutral on its face. It says nothing whatsoever about race, and the employer may have adopted it for entirely unrelated business reasons. But that policy, once actually applied, produces a disproportionate discriminatory effect on a group Title VII protects. Okay. Now, disparate impact requires no proof of discriminatory intent whatsoever. The effect of it alone, like standing on its own, can create liability under Title VII, even if the employer genuinely never intended or even realized that its policy would produce that effect. This theory was established in a case called Griggs versus Duke Power Company. It was decided in 1971, and we're going to talk about that in just a minute, but I want you to notice right now that this is a purely statutory theory. Again, it's coming from Congress's own words in Title VII as interpreted by the Supreme Court. It does not exist anywhere in the Constitution itself. It is a classic disparate impact, or an example of it would be like an employment test that has nothing to do with the actual job performance, but that happens in practice to somehow disproportionately screen out applicants from a group that the statute protects. Now, going back to kind of connect this to everything that we've already been talking about, I want to introduce you to a case called Washington versus Davis, decided in 1976. It establishes a rule that I think is absolutely essential for you to kind of internalize, and that is that equal protection claims brought directly under the 14th Amendment, they always require proof of discriminatory intent. Disparate impact, again, standing alone without any accompanying proof of intent, never violates the Constitution. Okay? And let me just make sure that that distinction is completely clear, because it is genuinely counterintuitive the first time that you encounter it. But if a government employer adopts a facially neutral policy, say a hiring test, and that test happens to disproportionately screen out applicants of a particular race, that disparate effect by itself is not enough to establish an equal protection violation. The plaintiff must additionally prove that the government actually adopted that policy with a discriminatory purpose in mind, not merely that the policy happens to produce an unequal, effect once it's applied. Now, place that constitutional rule directly alongside what we just learned about Title VII's disparate impact theory. Title VII's disparate impact theory, again, purely statutory, made by Congress, doesn't exist in the Constitution. It cannot be brought as a freestanding constitutional claim against any defendant at all. It can only be brought through a specific mechanism of Title VII statute itself, okay? And it's against an employer that's covered by that statute. And here's what that means in practical, concrete terms. Congress, through Title VII, went further than the Constitution independently requires. They made a deliberate legislative choice to prohibit facially neutral employment practices that produce discriminatory effects, which is a category of conduct the Equal Protection Doctrine, standing entirely on its own, simply does not reach. Okay? The 14th Amendment protects you from government action, but only from intentional discrimination. Title VII protects you from your employer's actions, and it reaches even purely unintentional, purely effect-based discrimination, so long as that employer happens to be covered by the statute. That is why understanding kind of these two tracks, the constitutional and statutory, matters so much, because the same underlying facts might produce a losing equal protection claim and a winning Title VII claim, depending entirely on which body of law is it's being litigated under. Okay, and depending on whether or not the defendant is a government actor or simply a private employer that the Constitution, state action doctrine doesn't reach. But I digress. We'll talk more about that. All right, so let's talk about the framework that's used to evaluate disparate treatment claims, which is the intentional discrimination theory that we just talked about, because in practice, most individual discrimination lawsuits proceed under this framework. So McDonnell Douglas Corporation versus Green, decided unanimously by the Supreme Court in 1973. It responds to a genuinely practical evidentiary problem. So as we already talked about, direct evidence of an employer's discriminatory intent is very rare. All right, employers, like even the ones who are in fact discriminating, don't tend to announce their motives in writing. So the court created a structured 3-step burden shifting framework specifically to help judges and juries to evaluate circumstantial evidence of the discriminatory intent in an organized and predictable way. So this framework has become, like in the decades since, kind of the genuine workhorse test that's used in an overwhelming majority of individual Title VII disparate treatment cases that get litigated today. So if you go on to practice in employment law in any capacity, you will encounter this framework. But one structural note or point here that's worth noting before we kind of go through even though the burden of production, meaning the obligation to come forward with some evidence on a particular point, shifts back and forth between the two sides as the case proceeds, the ultimate burden of persuasion, meaning the burden of actually convincing the judge or jury that discrimination occurred, always remains with the plaintiff throughout the entire case from start to finish. So step one is the plaintiff must establish what is called a prima facie case. And it's a Latin phrase meaning roughly that a case is sufficient on its face to proceed, absent some other explanation. So to establish this prima facie case, the plaintiff has to show that membership is in a protected class, that the plaintiff applied for, was qualified for, this position in question, that the plaintiff was nonetheless rejected despite being qualified, and that the position either remained open afterward or that the employer continued seeking applications from applicants with similar qualifications. This is generally not a difficult burden to meet, but it's designed as a relatively low threshold that is sufficient to raise an initial inference of discrimination and requires some, kind of response from the employer. Step two is once the plaintiff has established their prima facie case, the burden is going to shift to the employer, who now has to articulate a legitimate non-discriminatory reason for the adverse employment action it took. Now, I want you to notice the word articulate here. The employer's burden at this stage is genuinely light. The employer does not have to prove that its stated reason is actually true or that it is a particularly good business reason. It merely has to offer some legitimate, non-discriminatory explanation for the record. Okay. And perhaps you have a plaintiff, who's had like a poor performance review, or like a different candidate who had marginally like stronger qualifications on paper. Almost any legitimate business reason is going to satisfy this step. Now, step three, the burden is going to shift back to the plaintiff one last time, who now has to prove that the employer's stated reason was actually pretext. It's a cover story. It's offered to disguise this real discriminatory motive that lies underneath it. All right, this is in practice the step where the overwhelming majority of disparate treatment cases are actually won or lost. Proving pretext is going to typically require the plaintiff to show that the employer's stated reason is inconsistent, it's implausible, it was not applied like even-handedly to, someone who is similarly situated, outside of the protected class, or has simply changed very suspiciously, over time as litigation has progressed. Now let's talk about the case that actually created the disparate impact theory, and I want to kind of walk you through the facts. Um, Duke Power Company, which was out of North Carolina, they required a high school diploma and passing scores on 2 separate aptitude tests as a condition for certain jobs at that company. Now, Duke Power never actually demonstrated that either requirement, the diploma nor the test scores, were genuinely related to successful performance on the jobs in question. Those requirements, like whatever their intended purpose, they disproportionately excluded Black applicants. A direct foreseeable consequence of North Carolina's history of providing Black students with inferior segregated public education, the exact legacy of the Jim Crow system that we talked about. Now, Black employees at Duke Power challenged these requirements under Title VII, and I want you to notice something crucial about this lawsuit. There was no evidence whatsoever that Duke Power had adopted those requirements with any kind of conscious discriminatory intent. The company was not, like, so far as the record showed, deliberately trying to exclude Black applicants. It had simply adopted requirements that, whatever the company's actual motivation, produced discriminatory effects once applied against, like, the backdrop of this segregated educational system. So the Supreme Court, unanimously held that Title VII prescribes not only overt discrimination, but also practices that are fair in form, but discriminatory in operation, establishing in a very, simple sentence the entire disparate impact theory that we've been talking about. So I want you to notice something though, like how directly this language answers the exact question that many of these cases would go on to answer differently, for years. Um, Griggs holds that facially neutral practices with discriminatory effects violate Title VII, full stop. Okay. No intent required. Other cases, like Washington versus Davis, those hold that facially neutral practices with discriminatory effects do not, standing alone, violate the Constitution. Intent is required. Okay. Same underlying fact pattern. You have a neutral looking policy with an unequal real world effect. Two entirely different legal outcomes depending entirely on which body of law, whether statutory or constitutional, again, that you happen to be litigating under. So let's look at how we evaluate the disparate impact claim, because it proceeds in stages like the McDonnell Douglas, with the burden shifting between the parties. So step one is where the plaintiff has to show a statistical disparity. They have to demonstrate that a facially neutral policy produces a significantly disproportionate effect on a group that Title VII protects. That is typically going to require actual statistical evidence, like you have to compare pass rates, hiring rates, promotion rates, across the different demographic groups. Step two is where the burden is going to shift to the employer. And they have to prove that the challenge practice is job related and it's consistent with business necessity, meaning the employer must actually demonstrate with real evidence that the requirement genuinely predicts successful job performance, not merely assert that it seems like a reasonable practice, seems like it's okay to do. Step three is that even if the employer successfully proves business necessity, the plaintiff can still prevail by showing that a less discriminatory alternative practice existed, one that still would have served the employer's legitimate business needs, at least roughly as well, and that the employer simply refused to adopt it. Now, there's an important piece of legal history here because it goes to show that the statutory doctrine, even though settled, unanimously in that 1971 decision, can still be contested and can still shift over time. So in 1989, in a case called Ward's Cove Packing Company versus I think it's Antonio, the Supreme Court significantly kind of narrowed this disparate impact liability, shifting the burden of proving business necessity onto the plaintiff rather than leaving it with the employer where Griggs had originally placed it. And that was a considerably more employer friendly standard than, Griggs had given it. Now, Congress responded directly. Okay. The Civil Rights Act of 1991, in a specific provision, it's numbered Section 703K, it explicitly restored and codified the original Griggs framework, placing the business necessity burden squarely back on that employer, exactly where it had originally sat. Okay, so I want you to kind of notice what this little episode kind of demonstrates about the relative durability of judicially created doctrine versus doctrine that Congress has directly written into statutory text. The Supreme Court narrowed Griggs in Ward's Cove. But because Griggs' underlying framework rests on Congress' own statute rather than purely on judicial interpretation of the Constitution, Congress retained the power to simply legislate the more narrow interpretation back out of existence and entirely independent of what the court itself had said just 2 years earlier. Now, I want to kind of wrap up our substantive material with a recent decision that was handed down just last year because it kind of shows the entire body of doctrine is very much alive and still actively developing right up to a present moment. So you have Marlene Ames, a heterosexual woman working for the Ohio Department of Youth Services. She alleged that she was passed over for a promotion and then subsequently demoted in favor of colleagues who identified as LGBTQ, what is sometimes informally called a reverse discrimination claim, brought by the plaintiff belonging to what courts have historically treated as a majority group rather than a group that Title VII was originally enacted to primarily protect. Now, here is the specific legal problem that this case presented. The lower appellate court, the Sixth Circuit, they had applied what is called a background circumstances rule. And that's a rule requiring majority group plaintiffs, such as heterosexual plaintiffs or white plaintiffs, to satisfy an additional heightened evidentiary burden before they were even permitted to proceed to the ordinary McDonnell-Douglas framework that we just talked about. Now, in effect, several federal courts had developed a doctrine treating majority group plaintiffs differently and more skeptically at the very threshold of a kind of a Title VII case before even getting to those merits. Okay. Now, Justice Brown Jackson, writing for a unanimous court, 9-0, no dissents at all, held that this heightened threshold rule has no basis whatsoever in Title VII's actual statutory text. The statute itself, she reasoned, draws no distinction anywhere between majority group and minority group plaintiffs. Its protections against discrimination based on race and its other protected characteristics apply in precisely the same way to every plaintiff, regardless of which demographic group the plaintiffs happen to belong to. So the same McDonnell-Douglas burden-shifting framework that we talked about now applies identically to every single Title VII plaintiff, full stop. Okay, no extra like threshold hurdles or anything like that, simply because this is a majority group plaintiff specifically. And I was going to round this out by kind of recapping everything, but I'm just going to let you read it for yourself. Please reach out to me if you have any questions. Bye.